Hi, and welcome to the Ada K Show. I am Ada K. Brown, and am currently a criminal justice major, and I'm a deaf courtroom commentator. Grab a cup of Java, and let's dive in. Well, hello everybody. Long time no see. I haven't seen y'all in ages. Hello, I see Morales. I just did my American Sign Language class and zoomed back here, got on a little earlier than I thought. But we are going to start going through some of this shenanigans that has popped up with Miss Karen Reed. Oh my gosh, you guys. It is crazy. Cray. Oh, I am looking for, now I can, depending, I can stream. I know what to do, y'all. Stream Runkle of the Beta. Find him. Okay, I have permission to share his stream, and he's a lawyer. So what we're going to do is I'm going to interpret his stream, and then we will go in and talk what he doesn't talk about. Okay, guys? Because he told me I can share his stream anytime I want. So I've got the permission, I've got the go ahead. And so what we're going to do is we're going to get to the point where he's talking to
DK Cripple says there's a place in Edmonton that fills CO2 for paintballers and airsofters. Where is that? So there being a place is good, but knowing the actual place is even better. Carrie Morrissey and Brennan have plenty of hot air that they could donate to you. It doesn't need to be CO2. What does it use the CO2 for? As a pressurized gas that it uses to push out the flames. So push out the actual fuel.
Yeah.
So yeah, I can't replace it with something else. If it says CO2, it's getting CO2 because I am I'm not meant to picture, I guess. So here's the video. We'll just put me up in the corner here. There we go. Because maybe I can fit at the bottom. There we go. All right. And actually me fitting at the bottom works well because now you can compare and contrast. So this is from the video footage. And you can see that there is an individual right there who is, that is Aidan Carney, the also known as Turtle Boy. And he is in court for these proceedings, and he's got something on his laptop. Some guy wearing a red shirt and with white hair and with a big gun picture in his in the background. So and apparently Emily was also on. I don't have the timestamp for that, but yeah, somebody says I could point to myself. There's me right there. Emily was calling me the emotional support Canadian. So yeah, that's the what is it? So yeah, there I am on the screen, and yeah. No, I wasn't at the trial physically, but there I was on screen. So let's watch through this. I scheduled this to start a little bit sooner because I scheduled this to start a bit sooner so that we could get through it. And we're going to go for sort of as long as we can here, but we're going to go through a lot of Karen Reed discussion. And then once we get through the Karen Reed discussion, we will, if we got time, we'll talk a bit about Baldoni. Baldoni, I think, is fun. I think it's interesting, but I think it's sort of the less important of the two cases. No one's going to jail. Baldoni is the Hollywood knife fight. And tomorrow, this is the big thing, is that when we watch this, it's going to end with a bang, a really big bang. Judge Canone ends this basically saying, defense counsel, I need you to be back here to justify your existence. She says she has grave concerns about defense counsel, and she wants to, and she basically is like, you need to explain yourselves in the same way that like a parent might be like, or like, Lucy, you got some splaining to do kind of thing. No, I was not in the courtroom. I was on Turtle Boy's screen, which was in the courtroom. So anyway, that's going to be that hearing, that follow-up hearing is going to be coming back tomorrow. Now, I cannot cover the hearing live. I know that there are lots of places that are. Emily's covering it live. There's a bunch of others. I am going to cover it afterwards. I'm going to do either, depending on how long it is. If it's short, if it's a couple of hours, we're just going to run through it ourselves tomorrow night. I will be there tomorrow night to cover it. Or if it's like a 6-hour hearing, then we're going to do it as a recap where we'll sort of condense it down. We'll look at the key moments and we will sort of see what's going on there. So, yeah. Anyway, let's have a look at this hearing. We're going to roll it at 1.25, I think. That seems like a good, and
Ask for me.
what is it? Whoa, Mrs. Runkle, let date night get rescheduled for this. Yes. I, as some of you know, I usually have a date night with Mrs. Runkle on Tuesday, and we sort of stick to it pretty carefully because we want to, it's important, right? It's important to have, some structure there. But I told Mrs. Runkle, I was like, I kind of have a thing I really want to cover on Tuesday. And she's like, okay. And I'm like, can we do date night tonight? And that was yesterday. And she's like, all right. So we went out for sushi. We went out and a bunch of things. Yes, we're going to talk about this. FBI has closed their investigation. There'll be no charges. Does this change the game? It might. And we'll talk about that. I don't know if it's true yet. Right? I don't know if it's accurate yet. So, yeah. But if it is, there's some strategic elements that I might consider, including for the defense. So let's roll here. Can you guys hear this? Give me a thumbs up if you can hear it.
There's no sound.
All right. I'm seeing people saying no, they can't hear it. That is awful. Let me fix that. Now, you might be wondering, what were they talking about? Nothing important.
So with the court's permission, I would ask Your Honor to endorse that agreement. Attorney Albano expresses his...
Can you hear it now? Thumbs up if you can hear it now. I'm seeing the negative Ghost Rider. It takes about 10 seconds of delay for me to see what you're seeing. So, okay, I'm seeing people saying now. Okay, so what are they doing now? Right now, they are going through, and there was a bunch of things that he wanted from news organizations. Those news organizations have agreed to provide it. So, yeah, that's kind of the beginning sort of housekeeping stuff. Now that the audio is working, we'll cut to sort of the more interesting applications, and I have to interrupt in order to do this. Come on. There we go. There we go. Sandy says for another date night later in the week. Thank you, Sandy. Much appreciated. It probably won't happen this week because Mrs. Runkle is insanely busy this week. Mrs. Runkle is she's doing all the things. So okay, let's get Jackson up on the stage here and go ahead.
Apparently has been stored, or at least we believed at the time last week, had been stored on some sort of an iCloud. We were told that this was an account of a retired detective, as explained by Mr. Brennan. We met after court. Mr. Brennan told us that we told Mr. Brennan that we did not need an expert to fly out and go through all the machinations.
Okay, so let's talk about what they're asking for. They're asking for a forensically sound copy of the surveillance footage. Now, what does it mean to be forensically sound? Well, let's give an example of what is and is not forensically sound. Let's say that you wanted to get a forensically sound copy of my computer, right? And the way you would do that is you come in and you take the you take that hard drive and you get a bit for bit copy. But what you don't, and you do that with special equipment, including a read blocker that prevents amending anything there. The other thing that you get, and I see somebody saying louder, please. Yes, I'll try to fix that to be a little louder. We will. I've got a thing for fixie. There we go. We'll try that. Hopefully, it'll help. So,
Training.
what you can't do is you can't just go on to my computer and hit Control C to copy everything and then Control V to paste it over onto a new drive, because metadata is data about data, right? And so the metadata, when you actually look at like a file. So let's say you've got, this wrapper. I've got a wrapper here. Let's say this wrapper is your file, right? And so I had some Skittles like a moment before the stream started. So let's say this wrapper is your file. And now on the metadata would be if we take the wrapper and we put it into an envelope. And on that envelope, we indicate a bunch of things, like what time we put it in the envelope and, where it was made and so forth. Now, the thing is that when you copy it, a byte for byte copy would be that you copy the wrapper and copy the envelope, right? The problem is that when you do a Control C, Control V copy, what you get isn't a byte for byte copy. It's not that. It's that you take the contents out and you put it into a new envelope, right? It's I'm laughing at that notion. It's from Halloween candy. I've still got Halloween candy left in February, but yeah, so basically it makes a new envelope. Now, some of the data on that envelope might be the same. Like it might copy the creation date and keep that the same, but you want to keep certain other things. For instance, the last modified date, you're going to want that to be the original last modified date as opposed to the new last modified date, which will be when you hit Control C and Control V, right? So, and this becomes really important if you have questions around when something was doing something with the data. Like, for example, one thing that comes up where you have a lot of issues around forensically sound copies is when you've got people who have bad pictures, right? So, you know, and we're using a YouTube friendly euphemism, right? If you want, now let's say we want to prosecute Bob for bad pictures, right? And these bad pictures are found on a computer after Bob moves out. Bob was staying with roommates. Bob abruptly leaves for some reason. Nobody knows why, but Bob abruptly leaves. And then, you know, the roommates, they're like, well, if Bob is just leaving this computer behind, we're going to use it, right? And so they get on the computer and they're like, okay, we're going to use this computer. And then 2 weeks afterwards, one of the roommates goes, holy crap, there's a bunch of horrible pictures on this computer. Bob needs to go to jail, right? So that's our sort of issue. The problem is that the timeline could be really important in this hypothetical that I've given you. Because if the picture was created back when Bob lived there, then that is evidence that maybe Bob did it, right? Especially if Bob wasn't letting anyone use his computers afterwards. However, if the created date for these images is after Bob moved out, after Bob was gone, then Bob is probably innocent, right? And so the key thing is that you really want to make sure that you get that forensically sound copy and that you can figure these things out with the metadata. You can't just go and drag it over, because when you do, you might end up, you know, the computer might decide that it needs a new created date, and that new created date is after Bob moved out. And so Bob might be guilty, and you might accidentally create a situation where now Bob looks like he's innocent. And that's not, yeah, I see somebody saying that I should have picked a different name. I should have picked a Jared about this one. So, but yeah, this is the thing, right? And the key issues on this case are going to be issues of when did the cops know? When did the cops know about these files? When, you know, that's what they want to get, right? And Charlene Anderson, this is a very common scenario, right? I once worked at a computer repair shop. A guy brought in a computer that he said was acting flaky, opened up the hard drive and found lots of CP on it. Called the sheriff immediately. That is a very common scenario. I actually had a client who took his computer, and his computer was clean, but the repair shop got his computer confused with someone else. So yeah, he got charged up until they figured out that it wasn't actually his computer. Okay, so this is why they want a forensically sound copy. This is why they can't just say, we need any copy. It's, we need a forensically sound copy, because a forensically unsound copy, well, that gets them the actual content of the video, right? That actually gets them what's on the video, but it doesn't get them the information about what's on the video. It doesn't get them the information about how the video was created and when it was touched and when it was moved and when it was all of these things that might be critical for him cross-examining the police officers or bringing a motion to have this thrown out, right? That's the key thing. If we go back to our envelope, thing, the envelope of a letter can sometimes be really good evidence because, for instance, let's say it is stamped by the post office as having come at, a particular time and from a particular place. Well, that could be the most important piece of evidence. It might be that the actual letter inside the envelope isn't something we care about, right? It might be that we just don't care at all about the letter in the envelope, that the letter is meaningless. But for instance, the fact that it was sent might be super important, right? The only thing we care about from the letter is that it was sent from the guy who was killed. And it was sent a week ago, which tells us that the guy who was killed had to be alive a week ago, right? Because that's when he would have sent it. that could be really important. And if you lose that envelope, then it can be a really, really, really big deal. This is what they're worried about, is essentially we don't want to lose the envelope, because in this case, the envelope might be what tells us, what tells us which officer might be lying or might have lied at a previous hearing. This is the critical thing. So that's what he's fighting for, just, as an explanation here. And yeah, okay.
Having someone present, if all the information was
And let's actually
download from some iCloud account, unnamed iCloud account, as long as that was videotaped, we were fine with it. And that was basically the agreement. That was the information that we had at the time. We were predicating that on a conversation that we had with Mr. Brennan in January, I think it was January 22nd. He indicated that he went to Canton PD the same date, and the court will recall December 12th was the date of what I've referred to as sort of the wild goose chase, that we sent an expert out, et cetera. That same afternoon, apparently Mr. Brennan went to the Canton Police Department and found out that there was, in fact, additional video, which was news to us. He claims that it was news to him. And putting aside how odd that is, after 3 years of being told we have everything, he went on to explain in very specific form in a telephone conversation that he had met with a retired detective. At the time, he could not remember the detective's name. He said that the detective believed that he kept a copy of the January 29 video that we were looking for, and that he said that it was on a work computer's iCloud account. Mr. Brennan said that they intended to download it from the iCloud, turn it over, and that's the point at which we said, if you don't mind, just hold on that, because we're litigating ultimately this issue, which was the litigation we had on February 6th. So we had the hearing. The day after court, on the 6th, after we reached this agreement that the iCloud would just be downloaded and videoed, we received an email from Ms. McLaughlin, and that changed the parameters of what we had believed and what we'd been told by Mr. Brennan, and it sounded more like this. The Commonwealth changed the story from some work computer iCloud account to the footage was being stored on what's called the, quote, department's video file system. It's very different than a retired.
So I just want to stop and say how weird it is that there's all of these different places where this data could have ended up on, right? And why this data wasn't turned over for the first trial. Like, if I'm the judge and I'm finding out that this data is showing up for the next trial, I am just like absolutely stunned and going, wait a minute, you had this video. Why did you not have this at the outset? Why did you not give this, to the defense right at the beginning? I'm seeing somebody saying they want more loudness from the court feed. We can do more loudness. I have enhanced the loudness of the court feed. We will see on that one. So, I mean, yeah, this is the sort of thing that should be a grave concern, as people have pointed out. Like, there's this video, and where is it? The other thing is, what do you call it? I've started a goal. People have said start a goal. So the goal is I will have a scotch if we hit the goal. It's funny because just about every stream, if I don't drink, I get people saying that they think I'm drinking. So, all right, but I'll have a scotch. We'll get that started if we hit the goal. Okay, so here we go.
Officers or retired detectives' work computers iCloud, which is what Mr. Brennan believed at the time and what we were led to believe at the time. So we asked for clarification. Ms. Little sent an email saying, I'm confused. Now you're talking about something that looks like a much more formal system called the CPD video file system. So we want, that's fine, no problem, download the videos, but we want the metadata and the log files that are associated with that. If it's on a formal file system, it's going to have metadata for the upload, for any access to the data, and for the download. We want the metadata.
Now, some people are noting that there are spoilers on this one, which is that the defense loses this one, and we'll talk about why the judge denies it and whether we think it's a good idea. But he's saying, like, listen, the video is one thing. We need the stuff around the video. And the thing is that the metadata at this point should always be given, right? It should always be given out. Metadata can be critical. The other thing metadata can often help you do is determine if something has been faked or tampered with, because sometimes like editing programs will put their own metadata in there. Yeah, it's a whole thing. I think like the thing is they should definitely get the metadata. It's obvious, right?
And the log files as well. And that's the key entirely to the audit trail that we're interested in. Historically, we have been asking for videos, for all this video surveillance to be preserved and provided for about 3 years. And this has been one of the centerpieces of this litigation. When we asked for that additional metadata and the log files, Mr. Brennan, in my opinion, took an odd position, which is, nope, we had an agreement. We met right back there in that room. We said that you could videotape the download of the videos. You don't get anything else. If you want anything else, go to court and file a motion, which is why we had to file this motion. We don't think that it was necessary. This is metadata that is literally in the Commonwealth's possession as we speak. They have it. We're entitled to it. It's simple. That's all we're asking for.
I actually do think this is extremely unusual, right? Like that it's extremely unusual. If I ask for like, metadata can sometimes be super important. And yeah. Gon says, have I seen the New York Times article on YouTube gun culture? I have not. This is maddening. Like, I don't know why the Commonwealth isn't going, we want to turn this over in a forensically sound way, right? I just don't understand why they wouldn't want to do that themselves.
Mr. Brennan referred to the video files being placed on Canton Police Department detective file, which is yet another name for where this mysterious video may be held. And we said, it's easy to get the metadata. Let's just do a quick forensic image. It'll take less than a day. And all we want is the metadata for the 24-hour period, 23 hours and 59 minutes to be exact. And we don't need to file the motion. The first question I have is, why would the Commonwealth even object to this? It doesn't seem like something that they would want to object to. This is in their possession. They know that they've got it or they've got access to it. Why wouldn't we get it? These videos, again, have been a pain point for this case. These videos have been a pain point for this case for time immemorial, since the beginning of the case.
And the thing is he's not wrong. Why wouldn't they want to turn this over? It makes no sense to me at all. But yeah, I don't get it.
We've been demanding that footage from 2022, January 29th, 2022. We were told explicitly on December 12th that no footage existed when we went out and had an expert look at the DVR. Their analyst actually called Mr. Brennan when our expert, who was on the floor at Canton PD, asked, are there any original files that are in the possession of Canton PD? The analyst went, I think her name was Colleen Crawford. It was Colleen Crawford. She went and called Mr. Brennan, according to our analyst. Mr. Brennan then informed Ms. Crawford to tell our expert, get it from the defense. Whatever, if you want original files, get it from the defense, knowing full well that we don't have it. If we had it, we wouldn't be there. And then it was that same day that miraculously the Canton Police Department revealed that in fact it did have some video footage on this either iCloud or video system.
This is insane to me that they're saying like, we don't have this video footage. And then suddenly this video footage comes into existence. It is absolutely nuts to me. Laura Lee Annie says, I'm late. What's wrong with Mrs. Runkle? Nothing is wrong with Mrs. Runkle. Mrs. Runkle is doing fine. We've moved our date night this week. She's just going to be super busy this week. This is bizarre to me that they're like, hey, we have an issue with this, right? This is bizarre. The only time I've ever had them have an issue about like disclosing electronic data is either if it's something that is completely irrelevant, and it's clearly not completely irrelevant here, but sometimes there's certain data that they just can't allow to leave their premises. So as an example of data they can't allow to leave the premises, bad pictures. And so when that happens, you can't like get a copy of it to send to your expert. You have to send your expert into the Crown's building, and get the expert to look at it there, because they're not gonna allow that to leave, right? So yeah.
We take the position very clearly that this is Brady information, it's exculpatory information. The audit trail is also Brady and exculpatory, because the audit trail will tell us information that we won't otherwise have from the raw video. How did the footage end up?
Okay, guys, if I keep doing this, I won't be able to interpret much longer. So let's skim through the trial. We need to get to the documents. And if he doesn't, okay, we're back at trial. I'm going to let him run.
Number 4, unredacted copy of all reports, communication, handwritten law enforcement notes, again, in the Birchmore case.
Then I'll put
Why?
him back on. Because we're already hour or more behind him, like backwards. Got to turn it around. If I had it backwards for me. Okay. It's wonderful. I love what we need to talk about this. So let me. Oh, he just called him complete douche. I love it. Okay, I'm going to turn him down. Just kind of keep an eye. He's going to go over some of this, but I want us to go over some of this. And I know that's some reasons why you're here. Okay. So we had a lot of stuff come down today. One. It's floating around. Oh, there we go. Okay. Number 1, we have the FBI is supposedly have dropped all the charges now. He said earlier, "I'm waiting for all that to come down." Just because it's said doesn't mean it's all exactly true. So they're waiting for the paper proof. I was upset about it because I believe this is gonna royally affect Aaron Reed's trial. Okay, he's talking about this law. So we're gonna go through this real quickly, and I just dropped a page. Why did I do that? There it is. Is that it? Nope. I gotta get it up. Hold on. There it is. I got it. Okay, 'cause I gotta read it. Okay. So the defense's motion to exclude certain testimony, and my deaf person had to go. So, I only right now sign when I know she's here. She's gonna come back. Defense motion to exclude certain testimony from the Commonwealth. I can't, for some reason, this will not let me embiggen it even if I go here. So this is all I can do, guys. So let me adjust this. There we go. That better? Someone didn't like me being in it. Here comes Karen Reed, the defendant, yada, yada, yada. Okay. Massachusetts in the evening of January 12th, a second with a G. What is this? With a G. In the early morning hours of January 29, 22. We're not gonna read all that. Compelled, Commonwealth has filed to meet the burden. Oh, 22, exclusion of the testimony is Commonwealth has failed to meet the burden under the Albert London framework as both Mr. Gilman's qualification and methodology. Okay, we are talking about now comes the defendant, Ms. Reed. Yeah, we wanna read this. Respectfully moves the honorable court to exclude the testimony of Robert Gilman of concerning the hardness of the ground around the lawn area on 34 Fairview in Mass. Okay, they have hired. I do have an echo. Okay, give me a minute. I don't know why I have an echo. Why do I have an echo? Is that better? Let me do that. Tell me if it's better, Nancy Rose. Thank you. Nosy Rosie, thank you. Let me know if it's anybody else has got an echo. I did make an adjustment. See if it's better. Why on God's green earth are you going to waste money hiring. Oh, no, can't do that. It makes it smaller. Hiring a meteorologist to say that it was 20 degrees and the ground was hard as a rock. And that's how he got the cut on the back of the head. And that's how, oh my God, this is going to get crazy. Massachusetts in the evening of January 2nd, 2022, early morning hours of 29th. He was trying to put 29th. Exclusion of the testimony is compelled because the Commonwealth failed to meet the burden under the Daubert-Langdon framework as to both Mr. Gilman's qualifications and meteorology. See the yada, 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 that Mr. Gilman is not qualified to render an opinion on the subject of the hardness of the ground that he proffers. I still laughing at Canadian. I know, right? Mr. Gilman nor the Commonwealth has put forth any information regarding Mr. Gilman's qualifications as an expert about the ground's hardness. And the geology, hydrology, and other like scientific precepts necessary to opine the supposed hardness. Maybe I should sing this. It feels like a song. It does. Additionally, the Commonwealth has failed to satisfy the methodology prong of the Daubert-Langdon analyst because Mr. Gilman offers no meteorology of any possesses or proffers, no proffers. They got typos and I'm finding them. A methodology of any kind in his report or any of the other. Oh my gosh, you have if, of any, and of the that are misspelled and lined together. Oh my gosh. Seriously. Of any of the other materials supplied by the Commonwealth, whoever typed this, I can do better than this. Gilman cannot show that that has lacked I gotta read it over here. Mr. Gilman cannot show that his lacking methodology is generally accepted and relevant in the scientific communities, as there is no methodology scrutinized. Failure of either Albert Langdon should be Albert Langdon prong requires exclusion of the proffered testimony. Mr. Gilman failed on both prongs. Who typed this? I want to know. I need to know. The Commonwealth fails to meet the burden to establish the requisite qualifications of Mr. Gilman as an expert to testify on the ordinance. So what they're wanting to do, long story short, they want to question him. It is the defendant's burden to establish their proper expert testimony will assess the tier of fact understanding the of evidence will determine the fact of issue. Blah, 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 blah. They cited the crucial issue in Massachusetts for the Alfred Langdon inquiry is whether the proffered witness is qualified to give an expert opinion regarding the subject. Oh my gosh, look at all the typos. Subject matter of his testimony, Commonwealth citation. The subject matter of the proposed testimony, another. I'm dyslexic as hell, and this is driving me crazy. Testimony of Mr. Gilman as described in his certified weather statement report dated February 3rd of 25. Report is the condition, particularly the hardness of the. Can you not separate of and the ground in the lawn area? Can you not they don't know what a space bar is. Who in the Sam Hale? That's who typed it right there. Dude, go back to school. Because when a dyslexic person such as myself is calling you out, this is bad, y'all. Okay, let me certified weather report. The lawn area of 34 Fairview in Canton, Mass. On Saturday, January 29, 22. See affidavit. Yeah, see affidavit of Robert J. Let's see, dated February 21st, 25, blah, 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 blah. An expert witness is not permitted to testify in the matter is beyond his area of expertise or competency or Mr. Gilman received a bachelor's of science. What? Another. Okay, do me a favor. Haley Mouse, you have a copy of this? Will you go through and count all the grammatical errors for me? I gotta know. Please, Haley Mouse. If you can't, I'm good with it. But I thought that would be funny to find out. Mr. Gilman received a bachelor's of science degree in meteorology from Pennsylvania State University in 1979. God, y'all, I was only 8 years old. Really? Dude, you that old? Whew. Lists 7 different work experiences, including his current role for a chief meteorologist for the Precision Weather Forecasting and New England Weather Service. Oh, oh my God, is it cutting out again? Hold on. Okay, there we go. Found the sound problem. Sorry about that. I hate it when I have 3 places this sound button can be moved. Okay. So what I said was, is the weather forecasting in New England position held since 1980s. He's fielded geology, hydrology, and or any other irrelevant scientific field related to the study of the ground in any sense, especially not the hardness of the ground, CID. Okay, y'all, let me just say this. I had to take a geology class and it sucks. I don't wanna study about fossils and how hard the ground is and what kind of conditions create what kind of fossils. That's not my field. But when you are talking about the ground, the hardness of the ground, the type of ground, how weather affects the ground, y'all, that is not a meteorologist. Not a meteorologist. Sorry, guys. I said my son was playing a game and he got so loud I had to go shut his door. Fact. None of the information contained within any of the documents provided by the Commonwealth with Mr. Gilman professional experiences relates in any I love this, relates in any way to expertise on the subject determining the hardness of the ground. The report that Mr. Gilman opines that the ground in the lawn area 34 Fairview, another typo, Massachusetts on Saturday, January 29th of 2022 was hard as a rock due to the frost below. Massachusetts on Sunday, January 29, 22 was hard as a rock due to the frost below. Is signed at the bottom by Mr. Gillum as a certified weather reporter, notably not a report on the hardness of the ground. See, Mr. Gilman wrote this report and apparently intends to testify in his capacity as a meteorologist, not an expert relevant in the science of geology or hydration determining the hardness of the ground. Thank you. Thank you very much. I would be pining more towards the fact that John O'Keefe's head hit the hydrant and not the ground, because the type of tear in the back of the head is a hit and rub. Well, I guess you could do it on the ground, but it makes more common sense that him falling would create and hitting his head on the hydrant would create more of a gash in the back of the head than his head hitting the ground, and I'm not kidding when I say that. And Neil has a rough spot driving me crazy. So, accordingly to the Commonwealth has failed to meet the burden to show Mr. Gilman is qualified expert in knowledge in any skill representing training or education of the science of determining the hardness of the ground. He must be excluded from testifying on the topic of problem. The Commonwealth has to and cannot meet the burden that Mr. Gilman's methodology is reliable. I know, right? I'm just like, "Are you kidding me?" It was snowy, the ground was cold, but do you know what? There was a hard, cold fire hydrant made out of heavy metal. Now are you gonna get in there and get us a firefighter to determine that the metal is hard enough and the makeup of that metal in that fire hydrant could have caused such injury? No, firemen can't do that. They can say it's cold and hard, but they can't tell you why. In order for the pow pow is it Dalbert? Wasn't it supposed to be a D in the beginning and now it's a P unless it let me do this. I'm gonna see if that's legit. That's not what I want. Come on. You're not gonna copy? It won't copy. Okay, do it this way. It's supposed to be a Dalbert, not a Palbert. I was right. I may get the full-time position, so that'd be wonderful. Minnie Mouse, did you hear me? Serious. If you don't, I'll count them later and come back and tell y'all how many. But it's not Palbert, it's Dalbert. I knew that was wrong. I knew it. How many mistakes are in this, including the Palbert? Burden the Commonwealth must show that Mr. Gilman's proposed testimony is a product of reliable principles and methods. It's Dalbert, and this is like the whole thing after the first 2 paragraphs have been Palbert and not Dalbert. I'm surprised the judge didn't kick this back and say, "Redo it." The Commonwealth must show that and you know what? The prosecution can get up there and say, "I don't know what you're talking about with this motion, sir, because there's no such thing as a Palbert Langdon, so what the hell Linigan, so what the hell are we doing?" In the principles and methods, Mr. Gilman has reliably applied the principles and methods of facts in these cases. I would love to see EDVs. I'm gonna watch her read this. I would love to see her reaction to this. This is shameful. You're right. The existence of requirements to show that the purpose expert testimony is a product of reliable science and methodology presupposes that there is a methodology to analyze Mr. Gilman's report in devoid of any substance, which could even be a liberty construed, I can't, liberally construed as methodology of any kind for reaching its conclusions related to the condition on the ground. No, that's okay, hon. I understand. I was half serious, half sarcastic. Oh, and these connected all the time. The full extent of the information on the subject of the conditions of the ground in the lawn area of 34, anything with OF is gonna be no space. Of 34, of D, of and is all gonna be one word. Fairview, Canton, Mass, Saturday in January 22. Why is there space and all that there from and here? From all of the materials of the that's how I'm gonna start saying it, of the materials provided in the Commonwealth related to Mr. Gilman as it follows. The type of lawn area would have been hard as a rock due to the frost below and the freezing of the soil. Bitch, please. As a proponent of the claimed evidence, the Commonwealth must provide a preponderance of evidence that Mr. Gilman's method and procedure processes behind his opinion are scientifically reliable. The Commonwealth introduced a defect with the application. I love you guys over as the gavel drops, but this is starting to piss me off. Covering words of legal principle of the present facts that Mr. Gilman is no method of processing behind the bare opinion that even hints at a scientific something reliability. By the way, I love gavel drops. If you ever need court documents, go to as the gavel drops. We absolutely love, love, love them. I'm just struggling with the reading sometimes. A proposed expert opinion should be disregarded where it amounts to no more than mere speculation and guess of subordinate facts not given adequate support and conclusion. The opinion of a proposed expert must be based on a more conjured surmise and speculation, else it should be excluded. Mr. Gilman's opinion is that the ground was hard as a rock cannot be reasonably viewed as anything other than I need to get that stopped. I forgot. Stop it. My bad. Forgive me. I did that. Mhm. My bad. My bad. My bad. Yeah, this is after hours. I've been on live for almost 12 hours. Else it should be excluded. Mr. Gilman's opinion was hard as a rock, cannot reasonably be viewed as anything other than a mere supported speculation and is subject to subjective belief. For this reason, the court must, in a matter of law, fail to qualify Mr. Gilman. Yada 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 yada. Guys, this document is so bad, so bad. I am shocked, shocked, shocked. Um, so I hope you get the full-time position, honey bun. I really do. I really, really do. Yes. We're shooketh. Shooketh. As gavel drops for all your court documents need read, like we're just reading right now. We thank you so much for your supplying of all of our documents, and we bless you. And if anybody uses their documents, make sure you give credit. Go to As a Gavel Drops, register, validate your account, and you too can read all of these lovely documents at your leisure. So that to me was like my sister would say, "Beach, please." Oh, oh no. No way they typed this. Okay, I gotta look at this because something I'm looking at is totally messed up. Okay, so let's share this page, why don't we? Now we need to share this one. Karen Reed and the Commonwealth, and the decisions of said Commonwealth. And this is not gonna be fun to read. I am really upset about this document. I have to be honest, I'm not happy about this document. Okay, here we go. Rulings on the motion heard on February 18th of 2025. Let me just give you the down low. Are you ready for the down low? Commonwealth wins everything. Karen Wren wins nothing. Surprise! Not much. Defense's motion to compel video surveillance proper for a forward motion is denied. Oh, the Commonwealth is to comply with Mass R blah 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 effective March 1st of 2025, which provides a pertinent part that the prosecutor shall permit the defense to discover, inspect a copy all photographs, videos, audio recordings in possession of the prosecution team after hearing on February 6th of 2025. The parties reached an agreement that the Commonwealth would have a matter of possession, team copy, surveillance video, yada yada. The process would be video recorded. There is no affidavit of an expert or any evidence before the court that the procedure agreed to by the skilled counsel for both parties would result in a destruction of metadata. The proceedings agreed to by the parties satisfies Rule 14(1)(g) and complies with the court order of October 5th, 2023. Motion for admission I can't say that. Advice or whatever. 486, the affidavit of counsel is insufficient. Attorney Yannetti will provide additional affidavit motion under advisement. The defendant's motion to compel discovery, proper 495. We are in the 500s and 15s now, I think. Yeah, I know. Yeah, none of this surprises me. Defense request defense request number 1, allowed in part and denied in part. The Commonwealth has agreed and the court orders the production of an investigative material sought in the possession, custody, or control of the prosecution team. The Commonwealth has an ongoing obligation to provide items and information favorable to the defense. There is no requirement under Rule 14 that the Commonwealth create items that do not currently exist. Defense requests 2, 3, and 4 denied without prejudice. Means they can bring it again. I think the court does not have enough information to determine whether the request is beyond the scope of the Commonwealth's obligation under the Rule 14, or whether the request discovery is material and relevant. The court also understands that the material sought by federal protection officer counsels are free to file supplemental memoranda and or provide the court with the redacted version that both parties have in their possession, providing doing so is not in violation of the federal protective order. Defendant number 5 denied. This request discovery is outside the scope of Rule 14. Number 6, defendant 6 and blank, I don't know why that's cut, allowed by agreement. They agreed to it in court. Defense request number 9, denied in part overbroad. The Commonwealth must provide discovery consent with their obligations under new Rule 14A, 14B, 14.2F. Define, who typed this? Of work and of the again. Product does not include any items or information that the prosecutor is obligated to disclose as items or information favorable to the defense. The court is satisfied that the written response of the Commonwealth indicates a Commonwealth understanding of its directly obligations and outlined in the rule and the reported notes of the rules. Defense request number 10, allowed by agreement. See, everything that's allowed was by agreement in the last hearing. Nothing outside of that agreement that they made came through for them, as far as I know. Yeah, I'm like, seriously? I'm gonna go like my friend's daughters used to go, seriously? Okay, next. There's 6 of these, y'all. Yeah, I know. Okay, we have a motion to impound. Let me get this all set up for you. Okay, the defendant, Karen Reed, motion to impound portions of the defendant's motion to dismiss. Okay, what? Motion to impound. I don't know ADHD. The motion to impound portions of the defendant's motion to dismiss for extraordinary governmental misconduct. I like that last part, governmental misconduct. Now comes the defendant, Karen Reed. Ms. Reed is respectfully moves this honorable court for an order impounding portions of the defendant's motion to dismiss. Let's read that again. Here, I got to read it on the bigger one because it's blurry. Now comes the defendant, Ms. Karen Reed. Okay, respectfully moves this honorable court. Hey, Auntie Bev, we want you to, in order to impound the portions of the defense motion to dismiss for extraordinary governmental misconduct, affidavit of Alan Jackson, Esquire, filed in support thereof and supporting exhibits, namely the portion of the filing that are subject to. And see, what is all this stuff over it? Okay, guys, let me go to another format. This is driving me crazy. So let me go to their screen. We did that. That's what I want to open. Share. Okay, now let's see if this one's better. Motion to impound. We were on the second page. No? Okay, here we go. I'm going to move it over here so I can read it. Ms. Respectfully moves the honorable court to impound the portions of dismissed misconduct affidavit by Alan Jackson, Esquire, filed to support thereof and supporting exhibits, namely the portions of the filing that are subject to protective order include. So they want to squash this information that Mr. Jackson gave out. He had the boot. He had a boo-boo. Reference to information that is subject to federal protective order. Sidebar transcripts which remained impounded and communication obtained from law enforcement witnesses that are subject to protective order. Good cause exists for the impoundment of these portions of the motion because the materials are exhibits and exhibits are one subject to federal protective order sued by the United States District Court of the District Courts in Massachusetts and two subject to protective order issued by the court in support of the request of Mr. Reed hereby submits an unredacted copy of the defense motion to dismiss the affidavit. Okay. Wow. We're gonna have to we need to dive into that a little bit. Then we have this one here with Miss Little. Now, Miss Little is in support of the impounding, so she is validating the importance of the impounding by saying, I represent Karen Reed, the defendant, regarding the above captioned matter, prohactus, is that it? Prohactus? I represent the defendant regarding this matter. Good cause exists to file portions of the defense motion to dismiss extraordinary government misconduct, supporting affidavit of Alan J. Jackson Esquire and supporting exhibits, namely all reference the same thing that they just did. That's been filed and we've read this one. So this one's gone. Let me see what this one is. Okay, we've read this one with Miss Antibav. We've done the defensive stuff. Commonwealth notice of discovery. This ought to be good, y'all. Now comes the Commonwealth, and the above caption matter indicates that of this date, the following discovery materials have been provided for the defendant to the defense counsel. To the defendant through defense counsel. Okay. I'm tired, or my brain's just not wrapping. Copy of the Productive Room 14 material from the Norfolk District Attorney's Office, which was previously provided by email. Dead dates. Copy of law enforcement sustained findings. Copy of transcripts of Commonwealth of Agent Kearney. Copy of all data images and apertures provided in hand on 2/18. All right, that's it on that. So we have pretty much, I think, covered everything. Oh, I take that back. We got one last one, and it's a big one. Let me get it centered and proper. My computer wants to put it where I don't want it. Okay. Notice of appearance of continuing hearing. Commonwealth versus Karen Reed on February 25th. This is from Judge Bell. And it's one of those things like, you better come and you better come here with the ability to explain to me why you should still be standing here. February 25th of 2025, the name of the court order reviewing the hearing that began on February 18th of 25. Counselors to address the issue related to the defense recent production pursuant to Rule 14, especially as the materials produced related to prior representations made to the court on record by the defense counsel concerning the ARCA witness. Now, first of all, I don't think this is as bad as she's making it out to be, but it could be. In addition, because the Commonwealth referenced a transcript of a hearing on June 10th of 24. At the hearing on February 18th, 25, the Commonwealth is to provide a copy of that transcript to the defense and the court by the close of business date on the 21st, which has already passed. Beverly J. You know, and I'm not going to call her judge. Y'all, tomorrow is going to be spicy. We need to be well rested and ready to go. 10 o'clock Central Standard, 11 o'clock Eastern Time. I will not be doing the cemetery trial until all of this is done. This can be a few hours. I don't know why that's still strolling. I told you. This can be a few hours. This could be all year. Yeah, Runkle hasn't even begun to hit the documents. He's still in the court proceedings, so I'm not gonna go back to him. And my deaf person went to bed. So that's all the documents that we have as of now. I'm gonna double check make sure that I don't have anything that somebody dumped while we were live, because sometimes that happens. You guys, I really, really appreciate you joining me. Now, here's the thing. Okay, Missy. My dog saying, "Get your butt home, girl." So here's the thing for me. I'm like, look, I panicked. I don't like the fact that the feds have said there's no charges going to be brought against the Canton PD for this case. But I was thinking that's federal level. There's still state level. There's plenty of stuff state level that can be done eventually. But right now, it's all about Karen Reed. And if you notice by the documents, by the responses to the judge to the motions, unless the defense and the prosecution agreed to whatever it was in the courtroom on their last motion hearing, everything that the defense has requested has been denied. That to me is rough, because I find that it's unusually proportionate that the defense is losing everything and the prosecution gets whatever they want. So in my humble opinion, that is very slanted, highly suspicious. And then we have the situation with the attorneys. What I'm hoping to hear, and I don't know if that's what we're going to hear. What I'm hoping to hear was, Your Honor, when I asked that gentleman what I asked the gentleman, we had not paid him. We agreed previously in emails that we would reimburse them or pay for their travel, their expenses, which is kosher. They can do that. They cannot pay for their testimony, their time, and all that. And if he hadn't been paid, if that check hadn't been cleared or written and cleared the bank account prior to trial, then he's not lying. We've not paid you as of today. You've not been paid for your testimony. Is that correct? Is it a little sneaky? Yeah. Do both sides do it? Yeah, they do. So, I do believe that there may have, now, if I understand it correctly, I heard someone say that the conversations, that were going back and forth from Mr. Jackson and the ARCA people and about testimony and stuff were pretty vague. And when the person who was going to testify made a comment about something about what he was going to testify to, is that okay? Whatever. Jackson said, we need to stop talking. You can't be emailing me this. We can't be talking about this. If he did do that, then that's fine. But if he entertained the conversation, that's another thing. And understand, even though people sometimes can be called as an expert, they are not expert witnesses, meaning their sole job is witnessing and giving. Now, some people do that, but not this guy. So we'll see what happens tomorrow, and just pray that something goes right for Karen Reed tomorrow. I am just beyond myself sometimes at the frustrations. They had so much hope. Everything was so good about 2-3 weeks ago, and now today it has all come crashing down. Alternate juror says she's still in the emergency department. We're waiting for them to move her down. Oh. Her dad has COVID bronchitis. So keep the alternate juror and her family in your prayers where they go through this time with her father. Okay, guys, I got to get to bed. I have been gone all day because Breen and slimy. Yes, he is. He's slimy as a slug. He's slimy as a slug. We ought to call Brennan the slug. But I will be on 10 o'clock tomorrow, probably 9:45, but I'll be on in time for court. And we will go through all that tomorrow. Thank you so much for those who joined me today, stuck with me most of the day. It has been a day, and I'm looking forward to getting some good sleep. Okay, guys, be blessed. Have a fabulous night. Sweet dreams. Dream good thoughts for Karen Reed for tomorrow and her attorney team, because right now everybody is on the oh shit list. So nighty night. Be blessed. Have a good one. Boy. Thanks for watching. Please comment, like, share, and most importantly, subscribe. I hope you have an awesome day. Till next time, take care.